Employees who are dismissed for whistleblowing are automatically deemed to have been unfairly dismissed, irrespective of their length of service, and their compensation is not subject to the usual cap on unfair dismissal compensation. It is therefore important that employers are able to spot an act of whistleblowing, which is not always easy because it does not need to be labelled as such or brought under a whistleblowing policy, or even to be in writing in order to be protected. Employment law classifies whistleblowers as those who make what is called a protected disclosure to their employer. There are four constituent parts of a protected disclosure. First, the worker must disclose information. Disclosing information goes beyond merely making an allegation. An example of the distinction is given by case law in relation to the state of a hospital. The worker saying you are not complying with health and safety requirements would be an allegation rather than a disclosure of information. A disclosure of information would be saying something like, the woods have not been cleaned for the past 2 weeks. Yesterday, sharps were left lying around. Second, the information must tend to show unlawful activity, but need not be about criminal activity, and it could relate to any breach of a legal obligation by an employer. Third, the worker must have a reasonable belief that there is unlawful activity happening, but they do not have to be correct in that belief. To be protected as a whistleblower, the individual does not have to show that what they are saying is true, but rather only that they have a reasonable belief that it is true. The final element is that the individual must have a reasonable belief that the disclosure is made in the public interest. This means that if an individual is complaining only about their own treatment, this will not make them a whistleblower. For example, an employee raising a grievance about not being paid a bonus in breach of their contract of employment will not be a whistleblower. However, an employee raising a complaint that their large employer has been manipulating accounts to avoid paying bonuses to all of their employees might be considered to be a whistleblower. All four of these elements are nuanced, require careful consideration if an employer is in any doubt as to whether a particular individual is protected as a whistleblower.